All right, this is part 3, and I'm going to go ahead and continue trying to expose the corrupt for-profit corporation, CPS, which is the Child Predator Services Cartel, that is moving forward with tremendous speed and gaining power due to people's ignorance as to what is going on. So what I want to take a little bit of time to do is look into the indoctrination that is occurring within these dumbing down institutions. And then we will continue on a little bit later going over a section of the brochure or pamphlet that CPS gives to parents who have had an anonymous report made against them of an allegation of child abuse and neglect. Because that is what we are basing all of this on, but it opens up so many different areas. So on the screen here is a video training for North Carolina, their child welfare workers. So this training goes into safety plans and what you need to know about it in this state, and each state has similar types of trainings. So at this part in the video, they look at the type of safety action which requires separation or restriction. And let's go ahead and listen to what they are teaching these caseworkers and what judges, magistrates, lawyers, etc. are believing to be true for these what they call voluntary safety agreements or safety plans and due process of law when they drag people into these kangaroo anti-family courts. All right, here we go.
And finally, separation or restriction. This refers to the removal of any household member from the home for a period of time or otherwise interfering with a parent's custodial rights. Both are viewed as temporary actions. Separation may involve, among other things, the child temporarily moving to a safe environment, a friend moving into the home, the protective parent moving with the child to a safe environment, a parent agreeing not to have unsupervised contact with the child, a parent agreeing to forfeit decision-making authority over that child, or the alleged perpetrator agreeing to leave the home. Just a few examples. But I want to remind you that separation must always be the last resort when we are looking at the types of safety actions. For a child, a move out of his or her home is traumatic. The relationship with his or her parent is the most important one in their life.
Yes, it is.
Even if the parent is experiencing issues, the child still loves them and in most instances wants to continue living with them. Earlier we mentioned the importance of attention to both parents' rights and children's rights. Safety actions falling under the separation or restriction category affect a parent's custodial rights. When a county child welfare agency interferes with this right, reasonable procedural protections must be in place, and this protection for parents often takes the form of a hearing in juvenile court.
All right, I skipped ahead to the part where they go further into when should court interventions be sought. Here we go.
And so we've heard about the practice requirements. Now let's talk a little bit about when we should involve the court. Earlier we talked about family-centered practice being the cornerstone or key element of practice. And before we go into court intervention, here is a poll question. So we're going to bring it up, and the poll question is this. Involving the court is inconsistent with family-centered practice. Again, the poll question is, involving the court is inconsistent with family-centered practice. This is a yes, no, or I'm clueless answer. Okay. Most of you said no, it is not inconsistent, but we do have some clueless answers, and we do have some yes, it is inconsistent. Okay, I think we can close that poll now. Thank you very much. I appreciate that. Over half of you, about 87% of you said it was not inconsistent. Those of you who said that it is not, you're correct. Although it may seem that filing a petition in juvenile court could be detrimental to a parent and the family, allowing the parent to have that hearing or another form of due process when his or her protected custodial rights are implicated is consistent with family-centered social work practice. It gives them an opportunity to certainly tell their story. So let's talk about the times when court involvement must be pursued. If you will look at your screen. It must be pursued when an agreement that ensures safety of the children cannot be made between the parent and the county child welfare agency. You must involve the court. The temporary safety provider recommended by the family lives in another state unless there's a border agreement, like maybe between North or South Carolina. Court must be pursued. Or a temporary parental safety agreement involving separation is in effect and needs to remain in effect at the time the case decision is made. You must pursue the court. Let's look at the next slide. The most family-centered thing you can do is first try less intrusive strategies to keep the child safe. And if those aren't possible, then allow the parents the opportunity to be represented and have their case heard in court. Court is not all bad. Respecting the parents' rights to tell their side in court is family-centered. I'm sure you've probably heard this over and over again. This is from our colleague, Holly McNeil, the MRS consultant and trainer. Thanks, Holly, for that statement. We appreciate that.
In order for indoctrination to be successful, conditioning and programming has to occur. And as you saw at the end, there was positive reinforcement given for the desired response, operant conditioning, where you reward people and praise people to continue in a certain type of behavior or thinking. So let's look at what other types of training are given to these CPS caseworkers that makes them experts in assessing child abuse and neglect cases. This is Oregon.gov. It says CPS caseworkers must complete a comprehensive program that covers all aspects of child abuse, including symptoms of abuse, how to screen incoming reports of abuse, how to assess the future safety of a child, how to conduct an assessment of the family, how to interview victims, witnesses and alleged abusers, when to ask for law enforcement assistance, how to decide if abuse has actually occurred, how to decide if a child is safe, how to develop a safety plan, and when to close a case. In addition, all CPS supervisors and caseworkers are offered several days of in-service trainings to continually upgrade their knowledge and skill. They have to practice in order to perfect these techniques and to be further indoctrinated. You want to make sure that these types of trainings stick. So you have to have continued reinforcement. This should raise some serious red flags, especially when we look at their training is how to decide if abuse has actually occurred and how to decide if a child is safe. Okay? Once again, no due process of law and a true court of record before a jury of one's peers. That is what's needed for justice to be served. So these caseworkers and others working in cahoots with them believe that due process is occurring and that these courts are courts of law. So in order to dispel lies, we must present and look at truths. So here is a definition of court of record, and it's hard to make out on the screen, so I will leave a link to all of the resources I use in the description box for you to go back over later. So it says, court of record. Court of law means court of common law, a court for the people. To be a court of record, a court must have 4 characteristics and may have a 5th. They are: A, A judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it. B. Proceeding according to the course of common law. C. Its acts and judicial proceedings are enrolled or recorded for a perpetual memory and testimony. D. Has power to fine or imprison for contempt. And E. Generally possesses a seal. All right, so let's look at due process. Due course of law. This phrase is synonymous with due process of law or law of the land and means law in its regular course of administration through courts of justice. So this brings us to Article 3 in the Constitution, looking at judicial powers. I'm going to briefly go over this because it's very important to understand what is going on. So Article 3, Section 1 consists of one clause. 1. Vested judicial power in one Supreme Court and federal district courts, referred to as Article 3 courts. So they say today, so it's important to know, today the United States is divided into 94 districts, each with a district court. The Constitution holds that judges may remain in office during good behavior, meaning as long as they uphold the law of the land. Article 3, Section 2 consists of 3 clauses. 1. The judicial power extends to all cases in law and equity. Chancery courts are unconstitutional and do not constitute due process, as protected by Amendment 5. The process of law and equity are guided by Article 6, Clause 2, the right to be tried under the law of the land. Amendment 5, the right of due process. Amendment 7, the right to be heard under common law. Any court that denies these rights are unconstitutional. Any judge that makes such rulings in such a court is in bad behavior, wars against the Constitution, and is committing treason against the people. If such a judge does not yield to a writ of error, they should be indicted and arrested for treason. 2 talks about granted judicial jurisdiction. Jurisdiction is key in these cases, along with having no due process. And then 3 provided that all criminal cases be tried by a jury, judges are not authorized to make summary judgments. Doing so constitutes treason. Very important to understand how these crafty are trying to get away with working under the color of law. And I have a video clip that will help to show some of these schemes, and I'll play that in a little bit. Alright, so I'm going to briefly go over the jurisdiction and what types of craftiness has taken place. It says the jurisdiction of the United States District Courts is consensual by deceit because all bar lawyers and judges are taught in bar schools to proceed as chancery courts in the name of equity courts, which are not courts of record, which proceed according to statutes unwittingly as some form of hybrid of equity, admiralty, and maritime court, ruled by a judge de facto, settling commercial accounts in favor of corporatism, thereby hijacking the people unaware into foreign courts of fiction. This similarity has trickled down to every state, county, city, town, and village court. So here I'm going to go and speak about the case law of Wagner versus Armstrong. In another video, I'll go more into other case law that's out there when this brochure talks about, will I have to go to court? All right, Wagner versus Armstrong says, it is presumed that this custom arises from the circumstances that the equity jurisdiction, which is exercised by the courts of the various states, is assimilated to that possessed by the English courts of chancery. Indeed, in some of the states it is made identical therewith by statute, so far as conformable to our institutions. All right, so I'm going to play a video clip. This is an interview with Aaron Marcus, and he goes into how CPS subverts due process, their wicked schemes, and how they're getting away and trying to continue to bamboozle people and violate families' rights, destroying them one family at a time.
Talking, I found out that you're actually going to run for governor, but you've been very active in Oregon. Tell us about this ballot initiative that's coming up called that's named after your son.
Well, I'm the director of Safer Oregon PAC, and we have a couple ballot measures that are coming up for 2016. One of them is called Owen's Law for a Safer Oregon. Owen's Law basically changes the parameters of what the juvenile case McKeever versus Pennsylvania means as it applies to the Adoption and Safe Families Act. Right now they use that as a ruling to deny parents the right to a jury when they're facing these civil cases involving their kids in child welfare courts. We've been very active, and I traveled all the way across the country, leaving June 13th.
Let's pack that out for people. Let's tell them what the consequences of that are, because as you're describing that to me, you said because they've set up certain protections for juveniles, but even though you're in a court situation and they're accusing the parents, they say that you don't get a typical legal protection, in other words, counsel and that sort of thing. Explain that to us.
Okay, so how it works under the Adoption and Safe Families Act is they moved them from adult courts over to juvenile courts, saying it's a juvenile matter. And then they hide behind the ruling of McKeever versus Pennsylvania. And that ruling strictly states that juveniles do not have the right to a jury in criminal proceedings. So they say it's about the child, and then they deny the child the right to a jury in these child welfare cases, and it's really just a trick so they can sidestep a parent or an adult's due process. They make accusations at the adult, and they put an attorney on top of the child who always sides with whatever the court is doing. Now, to make matters worse, all the judges on most of these cases are pro tem judges, which means they're appointed there by the state Department of Justice or Judicial Department, which means the Attorney General or Solicitor General, depending on your state, the ones arguing the case for the CPS agency, they're the ones that get to decide whether or not the judge can maintain that position. It is a total smokescreen. The AG decides whether or not she wants to win or lose the case, and they deny parents due process and the right to a jury.
So let me interject here, because when we walk through the TSA checkpoints at the airport, we understand that they're violating the broad general prohibitions against government activity and getting away with it. So when we see things like what you're talking about, taking parents who are accused of a child abuse situation, they should have due process. We understand there's some people who do abuse their children, but there's a lot of people who are caught up in this process who are innocent but get nailed by this system because it wants their children. That's what we're concerned about. So what they do is essentially the same thing they do with your property, with civil asset forfeiture. They don't charge you with a crime, and they don't make it a criminal offense because they don't want to give you your due process, so they just seize your property and call it a civil action. They charge your property with a potential crime, and then you have to sue them in court if you want to try to get your property back. So what they do with a family, now that you're talking about with this a court decision, they move it out of a criminal accusation into a juvenile court, and then say, since in juvenile court you don't get the same rules of protection, now the parents have had their due process shut down. That's what we're seeing over and over again. And what we need to see, and I wanted to talk to Aaron, because what we need to see, or we need to see people who understand how their rights are being abused, and this happened to him personally, so he knows. We need to understand before they come for your family, you need to understand what they've done to other people's families so you can fix this broken predatory system.
So I think it's important to share people's experiences in order to open up dialogue and raise awareness as to the reality of what's going on. So this is an interview with Stacy Lynn and her experience in the courts, as her and her son have been severed, their relationship, and trauma has occurred in her life and her son's life.
My name is Stacy Lynn. I am from Larimer County, Colorado. My son Jaden is 9 years old. I have been Jaden's sole parent for his entire life until a judge in the 8th Judicial District brutally severed Jaden from his mom, his family, and his friends and his pets The judge demanded immediate custody change from me to the biological father, who was absent for the majority of Jaden's life. Jaden had never spent a single night or a single half afternoon alone with this man. I have not been accused of, charged with, or convicted of any wrongdoing. The witnesses for the opposition testified as to my excellent skills as a mother, and Jaden is now suffering emotional and psychological abuse. He does not understand what has happened to him. We are not allowed to talk about what has happened to him in our supervised visits. I am allowed to see Jaden for 2 hours per week in a court-ordered center. Jaden is suffering a horrifying demise because he was brutally severed from his entire life. The 8th Judicial District in Larimer County, Colorado is committing continuous crimes against my son and me. I am being punished for my investigative journalism regarding corruption in local government, including the Justice Center in Fort Collins, Colorado. I am asking Congress and my state elected officials to investigate the child abuse and other crimes that are being committed by the elected officials and by the 8th Judicial District.
I think this is a good place to talk about the brochure that CPS gives to parents. And at the section we are at, they talk about, will the police or anyone else be notified of DHS's involvement? So Stacy Lynn's story and countless other parents, this is part of why these types of atrocities, these crimes against humanity, are taking place. There's a multidisciplinary team in place. Now, I will revisit many topics in future videos because there's so much to cover, and it's difficult to just keep it the video short. But later I will go over being forced to have your children go and have medical exams done, and psychotropic drugs and different things that these children are being forced to take due to the trauma that has occurred in their lives. Not just children, but parents trying to cope with these abuses. It says, DHS is required to notify police of all suspected reports of abuse. DHS may request police assistance during the assessment. If you are a licensed in-home daycare provider, the Oregon Employment Department Child Care Division will be notified of the report. If you operate a child care facility, DHS may also be required to notify parents or guardians of all children attending your facility and tell them a report of child abuse has been made and that an assessment is being conducted. If a legal parent, guardian, or caregiver voluntarily, they say voluntarily, leaves the home during an assessment/interrogation investigation involving a sexual abuse allegation, the DHS worker will notify that person's county district attorney's DA office. The legal parent, guardian, or caregiver who voluntarily left the home during the assessment/interrogation investigation may ask the DA to have the county child abuse team review the case. DHS will contact all or any legal parents, guardian, or caregiver of the child, including a parent who does not live with the child, unless it is established that contact with that parent would be an adult victim or child, would put an adult victim or child in danger. So they say that you can turn to these state-funded for-profit corporations and these entities and hear the DA who works for the state and have the child abuse team that they put together, they monitor and make the rules for, and there's no accountability there. So it's just you and versus them. You can go to them in order to have your case further investigated. It makes no sense. On this Oregon.gov website, they talk about prosecution. It says, DHS does not prosecute abusive parents. Only a district attorney can prosecute a crime. District attorneys receive reports of possible criminal behavior from law enforcement officers. Possible criminal behavior. They have a multidisciplinary team. District attorneys are required to convene multidisciplinary teams to review child abuse cases. There are teams working in every county in Oregon. By legal mandate, they develop protocols to ensure the coordination of child abuse investigations. Child abuse is not just a DHS issue. The best way to protect our children, and strengthen families is through coordination of community services, including law enforcement, medical professionals, school officials, and the district attorney. There you have it. So everything we've gone over previously in this video of part 3 tells us how we've gotten, basically, the surface of how we've gotten here today. So to close this video out, I just want to focus on the police powers and how we've gotten to where we are today. All the information that I provided is just there for you to start to learn what is going on, because the rabbit hole goes very deep. But let's look at what it looks like to live in a police state. This isn't some foreign country. This is actually America today. So here we go. And I will end with that and then pick up in another video on more information on the section that we just went over. Thank you so much for watching.
How do you get to the point when police come to your home and take your child? What you're seeing is home video. Anna Nikolaev set up the camera herself when she noticed police outside her home.
I'm gonna grab your baby and don't resist and don't fight me, okay?
It began nearly 2 weeks ago when Anna and her husband Alex took their 5-month-old little boy Sammy to Sutter Memorial Hospital to be treated for flu symptoms. They didn't like the care their child was getting. For example, one day she asked why a nurse was giving her son antibiotics.
And I asked her what it is. She's like, antibiotics. And I asked her, for what is that? And she's like, I don't know. I'm like, you're working as a nurse and you don't even know what to give to my baby, for what?
She says the doctor later said he shouldn't have been on the antibiotics. Anna tells us Sammy suffers from a heart murmur and had been seeing a doctor at Sutter for regular treatment. After Sammy was treated for the flu symptoms, doctors at Sutter admitted him to the pediatric ICU to monitor his condition. After a few days, Anna says doctors began talking about heart surgery.
If we got the one mistake after another, like, I don't want to have my baby have a surgery in the hospital where I don't feel safe.
Anna argued with doctors about getting a second opinion. Without a proper discharge, she finally took Sammy out of the hospital to get that second opinion at Kaiser Permanente.
The police showed up there. They saw that the baby was fine. They told us that Sutter was telling them so much bad stuff that they thought that this baby is dying on their arms.
Anna showed us medical records from the doctor treating Sammy at Kaiser Permanente. The doctor described Sammy as clinically safe to go home with his parents. The doctor added, I do not have concern for the safety of the child at home with his parents.
So police saw it, they saw the report from the doctor, they said, okay guys, you have a good day, and they walked away.
But the next day, police and officials with Child Protective Services showed up at the couple's home. The father met them outside a short time later.
I was pushed against the building, smacked down. I said, am I being under arrest? Placed under arrest. He smacked me down onto the ground, yelled out, I think I got the keys to the house.
Police let themselves inside.
He's like, okay, let your son go, son go. So I had to let him go, and he cracked my arm so they could take Sammy. They took Sammy and they just walked away.
Now, when we spoke to police, they referred us to Child Protective Services. CPS won't say much about the case, but the mother just told us a short time ago that a CPS social worker told her the reason they took the baby is because of severe neglect, but she didn't elaborate what that neglect was. We contacted Sutter Memorial to get their side of the story. They told us that because the case was with law enforcement, we would have to get any information from them. Now, just a little while ago, we got word from Anna that she was going to be allowed in to see her baby, but we're told she's only going to be able to stay with the baby for about an hour, and that CPS is trying to find someone to take in the baby.